in disgrace. He's a leaker. We fired Comey, that fraud.
That phony, crooked Comey.
One of the best things is firing James Comey's out of there.
Former FBI Director James Comey has been a target of President Trump's for years. And after the president publicly pushed his attorney general to go after his political opponents, Comey is now indicted on felony charges, including obstruction of a congressional proceeding and making a false statement to Congress, tied to his Senate testimony from 2020.
My heart is broken for the Department of Justice, but I have great confidence in the federal judicial system, and I'm innocent. So let's have a trial and keep the faith.
And joining us now live to discuss is Erin Carr, Assistant Professor of Law at Seattle University. Thanks for being with us, Erin.
Good evening, Joyce.
So much to cover. First, what are the legal grounds on which James Comey was indicted, and how unprecedented is this?
Nearly every aspect of the indictment of James Comey is highly unusual. The short 2-page indictment makes little attempt to offer a legal basis in support of the charges and is largely devoid of details or evidence of a crime. The 2 federal charges brought against Mr. Comey also come only days after the former U.S. Attorney for the Eastern District of Virginia, himself appointed by the president, refused to indict Mr. Comey based on a lack of probable cause, was then promptly fired by the president, and immediately replaced with the president's former personal lawyer, an insurance attorney with no experience as a criminal prosecutor. The federal charges against Mr. Comey come as the statute of limitations is set to expire and coincide with a social media post by the president explicitly calling upon the Department of Justice to swiftly bring criminal charges.
How should we interpret the influence of politics in these federal charging decisions? I mean, is it politics? Is it justice, in your opinion?
In the half century since the Watergate crisis, Democratic and Republican presidents alike have demonstrated an understanding that the independent administration of justice requires that the president not use the tremendous power and resources of their office to influence the Department of Justice or to direct prosecutions. Mr. Trump, however, appears to be of the belief that it is appropriate to personally inject himself in criminal prosecutions. And this behavior is concerning because the indictment of Mr. Comey may very well encourage the president to target other political adversaries, including, for instance, the New York Attorney General, Letitia James, who brought a civil fraud case against the president, or Senator Adam Schiff, both of whom the president has already called on the Department of Justice to prosecute.
Why do you think the average American should be paying attention to this and should care about these kinds of indictments?
The president's direct involvement in the Department of Justice to use the law for targeted prosecutions affects not only the credibility of the Department of Justice itself, it threatens the reputation of the United States as a country based on the rule of law. Replacing independent prosecutorial decision-making with tweets by the president, the most powerful person in the country, would corrupt government institutions and undermine the integrity of the entire legal system. The weaponization of the Department of Justice would also likely have a significant and immediate chilling effect on speech, particularly political expression. And in terms of the administrative costs of politicizing the Department of Justice, we should expect that career federal prosecutors may very well choose to resign rather than attach their names to legally unsupportable criminal indictments, which will result potentially in the exodus of experienced career prosecutors.
We're going to return to this topic in the days ahead with some certainty. I want to turn quickly to comments made today by the Supreme Court Justice Clarence Thomas, who said that settled Supreme Court precedents should not be followed blindly, especially if a justice feels a previous decision was, quote, totally stupid. What did you make of that statement? What does that mean?
Well, Justice Thomas's comments, while concerning, are not inconsistent with the positions he has repeatedly expressed in his judicial opinions. For some time now, Justice Thomas has been vocal about his desire to have the court revisit landmark privacy and civil rights cases. He appears to be of the position that if a majority of the Supreme Court's 9 justices disagree with a legal precedent, regardless of how well established it is, that the court is empowered to simply overrule it. But such an approach to legal precedent is inherently in conflict with basic judicial principles. Most notably, under the American legal tradition of stare decisis, courts, including the Supreme Court, are bound to follow the rules of prior decisions unless there is a special justification or some compelling reason to overrule precedent. And a change in the composition of the Supreme Court is not a compelling reason to overrule precedent. Adherence to legal precedent is really essential in promoting stability in the law, and for that reason was endorsed by the Constitution's framers as necessary to limit abuse by judges. And without that strong commitment to legal precedent, the law is nothing more than whatever a majority of the justices proclaim it to be, which is not a form of judicial decision-making that instills confidence in the legal system or in the Supreme Court.
Erin Carr from Seattle University. Of course, you're talking about what have been norms for a long, long time, which arguably may not be any longer. But we appreciate your time. We'll have more conversations about this. Thanks.
Thank you, Joy.